Alison, thank you very much for that introduction. May I say at the outset, it is a great pleasure to be asked to speak to you today. To my shame, this is the first time I have stood in your Guildhall, although I have strong connections with the city, and what an amazing space it is. I am particularly delighted to be invited to speak on this special occasion, which marks the opening of the Foyle Family Justice Centre. At the outset, as some of you know, my practice in law as a barrister was largely in the area of family law, and I started in 1994 as a lawyer. And it was clear, I think I can say from the outset, that domestic abuse featured in very many of the cases that I was dealing with. And perhaps then there wasn't the appreciation of the issues relating to the topic that I think we now have. In terms of domestic abuse, there is obviously an interface directly with family law. But the first thing I always say is that family law is not an island area. It's clear to me, and it has been through my practice and as a judge, that it interfaces with so many other areas: criminal law, housing, education. The issues that arose during practice, and I think probably continue to arise, I won't dilate on at great length today, but let me mention 5. Firstly, the appreciation of the fact that there are different forms of domestic abuse. It is not confined to physical abuse. We do now have a greater appreciation of that. Secondly, the need for multidisciplinary, interdisciplinary work in this area. Thirdly, the need for safe havens and the ability for those affected to really feel free to communicate and then to enter safely the justice system. Fourthly, the effects on children within the domestic abuse setting. That's something that I think has developed and is appreciated much more over the years. Fifthly is the need to educate, and that again is something I think that continues to develop and is critical in this area. So matters have moved on from my start out in practice in 1994. There is also, I should say, I think, an overarching appreciation of the ethos of problem-solving justice in our jurisdiction. All of that said by way of introduction, I want to acknowledge the efforts of Marie Brown, the Director of Women's Aid here in Foyle, and her colleagues on what I believe to be a truly marvellous achievement, bringing accommodation, services and support together in one safe place. That is, to reduce the number of places a victim needs to visit for support, with a view to reducing the re-traumatisation of those affected by domestic abuse. The acquisition of the centre, particularly the 9 accommodation units where women and their children who are at a most frightening and vulnerable stage in their lives, must provide a very welcome haven and a real asset to the community here and hopefully beyond. That this centre will be the first co-located, multidisciplinary, interagency centre for domestic abuse in Northern Ireland, and indeed much further afield, is an accolade of which Foyle Women's Centre must rightly be proud. I don't underestimate the challenges faced in getting to this point, from the early vision of how the model might look and operate, through the production of complex business cases, the rigours of bringing so many bodies and agencies on board, right through all of the competing for funding, the identification of a site, the complexities of procurement, to laying the first brick. But you are there. And while all of this is continuing, it provides the most vital services to the people affected in this area. If I may turn to the issue of the interface with the justice system. Of course, justice is in the title of this centre, and the judiciary also has an important role to play in this initiative. I want to, in that sense, acknowledge District Judge McElholm for being clearly at the forefront of this initiative, for his ongoing support, and for representing the Northern Ireland judiciary so ably in this important and evolving area. I'm also aware that my predecessor, Sir Declan Morgan, is attending today, which is, it seems to me, a clear sign of his strong support, past and present, for initiatives such as this. He was always keen during his tenure to ensure that the judiciary were positively involved and ready to embrace any change that could have a positive impact on those affected by domestic violence. And I continue on that path. From my own perspective, I want to assure you that members of the judiciary are now very conscious of the particular difficulties faced in cases involving domestic abuse and the often long-term consequences on children and the entire families exposed to it. I welcome all progress in this area, including the recent recognition of coercive control within our legislative framework. And I am confident that our family judges fully understand the emotional and psychological harm that can be caused by one dominant bullying adult in a household where all others live in constant fear of an outburst. The impact of this fear on those affected can be as significant, and sometimes even more significant, than the impact of physical violence. District Judge McElholm has previously called for change and progress in this area. Women's Aid has also been proactive in seeking change, championing awareness raising and training. And Marie, you and Foyle Women's Centre were, it seems to me, ahead of the game on this one, providing training to the judiciary from a model in San Diego prior to any developments here on the legislation front, which has relied up to now on an indictable-only offence under the Offences Against the Person Act 1861, which requires proof of intention to commit another indictable offence. That's one example. Some of our recent Court of Appeal cases in Northern Ireland have also clearly and specifically taken into account the important research and development in other jurisdictions regarding this area of offending. In particular, Sir Declan, in a case in December 2020, specifically referred to the potential injury rather than the harm caused in the consideration. He observed that there was much to be said for consideration of a specific offence dealing with this conduct. I'm sure that we all welcome this year's Justice, Sexual Offences and Trafficking Victims Northern Ireland Act, which does create a specific offence of non-fatal strangulation. And I understand from colleagues that there are plans to commence the new offence in the first half of next year, a much-needed development which has come about as a result of the interaction of all those who are dedicated in this area. Let me mention a few other legal matters. Firstly, stalking. Stalking has been another area where change was much needed and desired. Thankfully, a new specific offence of stalking and an associated but separate offence of threatening and abusive behaviour were included in the Protection from Stalking Act this year. Those offences come into operation as the bill received royal assent in May 2022, and the Act includes provision, as some of you will know, for the introduction of stalking protection orders in this jurisdiction. On another level, in terms of how courts operate, I think it's important to mention recent changes which have come about as a result of the Domestic Abuse and Civil Proceedings Act. I know that the Department of Justice is currently working to reduce the financial burden of Article 8 proceedings on those affected by domestic abuse, and my staff are working to consider the legislative and operational implications in relation to how courts operate in this area. The highlight of this is the issue in relation to making courts accessible. This includes managing and, in some cases, prohibiting the cross-examination of those affected by domestic abuse by perpetrators. This, it seems to me, is a very welcome development in striving to reduce the re-traumatisation of those affected. In that sense, I recognise that it must be extremely frightening and potentially off-putting to have to appear in court at all, let alone have to come face to face with the person who has caused harm and abuse. And so I support what has been happening by way of the understanding of special measures within the legal system into a more coherent legal framework. It goes without saying that it is vital that members of the judiciary have the best and most up-to-date information available to them. And in relation to the legislative changes that I have mentioned in criminal and family law, the judiciary do have ongoing training in this area. And again, the strength of that is that we rely on our multidisciplinary partners as part of our training processes. We look at all aspects of this area of law and follow up on what is happening. And this is something that I think is very important, kept under review, and stresses the need for partnership between all of us who are engaged in this area. Working together across departments and with justice partners is also of clearly vital importance. In 2016, the Departments of Health and Justice created a 7-year plan under the Stopping Domestic and Sexual Violence and Abuse strategy. Much valuable progress has been made towards the vision of a Northern Ireland, to quote from the plan, in which domestic and sexual violence is not tolerated in any form, effective, tailored, preventative and responsive services are provided, all victims are supported, and perpetrators are held to account. This quotation, to my view, encapsulates all the areas that need to be addressed. I think we all know, however, that there is more to do, and the Ministers of Health and Justice, I understand, are planning ahead for a new strategic framework to be in place by 2023, which is very welcome, to ensure that this critical joined-up work continues. Alongside this work, it is encouraging to see the launch of the Equally Safe strategy led by the Executive Office to tackle violence against women and girls. Aside from the legislative developments, which I've only just touched on, judges are very well aware of the further challenges there are in working through the justice process, and understand that some of those affected by domestic abuse find it difficult to see proceedings through to a conclusion at this vulnerable time. It is important that we work with our justice partners in the PPS and the police and put supports in place for complainants to ensure that a higher number continue with prosecution and attend court to give evidence. And I think good work is being done in this area. When cases do come to court, the Northern Ireland Courts and Tribunals Service is constantly working to resolve issues as they arise and rolling out initiatives such as the promotion of evidence by LiveLink, listing cases where similar type cases are being heard on the same day, and sourcing appropriate and separate waiting areas. This is all part of the plan to make the court process as accessible as possible. During the time of COVID-19 and the uncertainty that we all experienced as people, which translated into the justice system, It was difficult to adapt our usual ways of working, however we did succeed. You will know, I think some of you, that the Northern Ireland Courts and Tribunals Services undertook a range of measures in liaison with the Lord Chief Justice to ensure that where possible court processes continued, albeit often in a different format. This is something to work on, and I think feeds into dealing with issues of domestic abuse in cases in the most effective way, whilst also maintaining the interests of justice, which is key to the consideration of any case. But by way of example, in some applications, such as ex parte applications, those affected by domestic abuse were enabled to make their applications online. We also developed the use of remote evidence centres in Northern Ireland for complainants, and that's something that I hope is developed further along with some of our online initiatives as a complement to our traditional legal structure. So ultimately, I think it is important to build on the positive tools and developments that were created during the COVID-19 times, as these can assist those who come within the justice system. I want to end by, I think, reiterating my support for this initiative. It is a remarkable achievement. The testament to that is your attendance today, the people who are attending and who will speak to you, both from home and further afield. The ultimate aim is the commitment here to ensure that those affected by domestic abuse are enabled in asserting their rights to the safeguard of the law. Finally, I want to congratulate you, Marie, and all of your colleagues in Women's Aid and those who assisted you in bringing you to this point. The creation of the Foyle Family Justice Centre will doubtlessly positively impact on many, many people who are at the lowest point in their lives. I wish you very well going forward with your work. Thank you very much.